Last 5 seconds. Yes. Ready. Start. The challenge in the present appeal is to an order passed by the High Court of Uttarakhand at Nainital on 20th July 2020, whereby the petition filed by the appellant under section 482 of the Code of Criminal Procedure 1973 for quashing the charge sheet as well as the summoning order dated 25th June 2020 was dismissed. The FIR number 173 in question was lodged by the respondent number 2 on 11th December 2019 at 23 hours in respect of an incident alleged to have occurred on 10 December 2019 at 10 hours against the appellants and other. The FIR was lodged for the offences under sections 452, for short the code 504, 506 and section 3110 and 31E of the Scheduled Caste and the Scheduled Tribes Prevention of Atrocities Act 1989. The said FIR, when translated, reads as under: respected SHO, with respect of registering of FIR, the complainant is presently resident of Gram New Bajeti Patti Chandak Tehsil and District Pithoragarh. I am constructing my house on my khet number 6195, 6196 and 6199, but Bansi Lal Pyare Lal, son of late Har Lal, Hitesh Verma, son of Shri Pyare Lal, Pavan Verma, son of Bansi Lal, Uma Verma, wife of Pyare Lal, and their Nepali domestic help Raju from past 6 months are now allowing the applicant to work on her fields. All the above persons used to abuse the applicant, her husband and other family members, and used to give death threats and use caste colored abuses on 10th December 2019 at around 10 am. All these persons entered illegally into 4 walls of her building and started hurling abuses on myself and my laborers and gave death threats and used caste related remarks, abuses, and took away the construction material such as cement, iron, rod, bricks. The applicant is a scheduled caste and all of the above persons uses caste remarks, abuses, used bad language and said that you are persons of bad caste and that we will not let you live in this mohalla vicinity. Respected sir, the applicant and her family has threat to her life from such persons. Thus, it is requested that an FIR may be lodged against such persons and necessary action may be taken against them. Pursuant to the FIR filed by respondent number 2, police filed a report disclosing offences under sections 504, 506 IPC and section 31X of the Act. Cognizance for the same was taken by the trial court on 25th June 2020. It is the said order which was challenged along with the charge sheet before the High Court, which was unsuccessful. On the other hand, on the basis of the statement of Mr. Pavan Verma, an FIR number 174 at about 23:47 hours was lodged on 11 December 2019 in respect of an occurrence which had taken place allegedly at 9:45 hours on 11 December 2019. A charge sheet in the said matter has been submitted against respondent number 2 and others. Thereafter, the learned Chief Judicial Magistrate Pithoragarh had taken cognizance for the offences under section 323 and 354 IPC against respondent number 2 and others on 2nd July 2020. The appellant invoked the jurisdiction of the High Court by way of a petition under section 482 of the Code to challenge the charge sheet and the order taking cognizance. The appellant relied upon Garage Pentia versus State of Andhra Pradesh and others 2008 12 SCC 531, wherein the allegation was of abusing the complainant in the name of their caste, and this court quashed the complaint. The attention of the High Court was drawn to another judgment reported as Asha Bhai Machindra Adagle versus State of Maharashtra and others 2009 3 SCC 789, wherein this court refused to quash the FIR on the ground that the caste of the accused was not mentioned in the first information report. The High Court found that both the above mentioned cases dealt with the same issue with regard to applicability of the provisions of the Act. It was observed by the High Court that the appellant had categorically admitted that the informant belonged to scheduled caste and that she and her labourers were abused. Therefore, the provisions of the Act were found to be applicable, and accordingly, after investigation, charge sheet has been submitted. The High Court dismissed the petition with the aforesaid findings. The learned counsel for the appellant argued that the disputes relating to the property are pending before the civil court and that the present FIR has been filed on patently false grounds by respondent number 2 only to harass the appellant and to abuse of process of law. It is argued that the allegations levelled in the FIR and the subsequent report submitted by the police after investigations does not disclose any offence under the Act. Furthermore, it is argued that the report neither discloses the caste of the informant nor the allegations are that they were made in public view. Also, the offending words are not purported to be made for the reason that the informant is a person belonging to scheduled caste. The learned counsel for the state, on the contrary, submitted that during investigations, certain persons have supported the version of the informant. Stop.